If your last name appears on this roll, your ancestor was legally entitled to land. Not symbolically, legally. In 1898, a federal commission sat down and started writing names into a book. Cherokee, Choctaw, Chickasaw, Creek, Seminole. Every name entered received a roll number, and every roll number carried something valuable attached to it, a legal claim to land. This is not a story about a broken promise made in secret. It's a story about a promise that was written down, formalized, numbered, and then dismantled in plain sight through the courts. If your surname is on this list, your family was owed something specific. Here is exactly how and why most of them never got to keep it. The story begins with paperwork, which is precisely why so few descendants ever hear about it. The body responsible for that paperwork, the Dawes Commission, had actually been created back in 1893, tasked with negotiating allotment agreements with 5 sovereign nations: the Cherokee, Choctaw, Chickasaw, Creek, and Seminole. For years, those nations resisted. Then, in 1898, Congress passed the Curtis Act, stripping the 5 tribes of the ability to refuse and giving the Commission the compulsory authority it hadn't had before. This was not a census in the way most people understand the word. It was not a head count taken for statistical convenience. It was a legal process, conducted name by name, that would determine who held a formal claim to land that had, until that point, belonged to each nation collectively. Before 1898, land within these nations was not divided into personal property the way it is today. It was held in common, governed by each nation's own laws, occupied and worked by citizens, but owned by no single person. The federal government wanted that changed. Dissolving communal ownership into individual, privately held parcels was the explicit goal of the broader allotment policy of the era, and the Curtis Act was the tool that finally forced it onto nations that had spent years fending it off. To divide land among individuals, the government first needed a definitive list of exactly who those individuals were. That list is what became the Dawes Rolls. Enrollment itself was neither quick nor uniform. Citizens of each nation had to appear before commission officials, establish their identity and their citizenship within the nation, and have that citizenship formally accepted or rejected. Entire families sometimes traveled significant distances to do this. Some were enrolled without difficulty. Others were denied, contested, or delayed for years, and the Commission's decisions on who counted as a citizen would go on to shape the fate of their descendants long after the ink had dried. But for those accepted, something concrete followed. Each enrolled citizen was assigned a roll number, permanently linked to their name, their nation, and their family. That number was not a formality. It was the legal key that unlocked an individual share of land. This is the detail almost no descendant today understands. Enrollment on the Dawes Rolls was not simply a record of belonging to a tribe. It was the precondition for receiving an allotment, a specific, surveyed, individually assigned parcel of land carved directly out of what had been collective territory. If your ancestor's name is on this roll, it means the federal government, at that exact moment, recognized them as legally entitled to land, not eligible in some abstract future sense. Entitled, immediately, as a matter of law. And yet ask most families with roots in these nations whether they know their ancestors' roll number, and the answer is almost always no. Ask whether they know an allotment was ever assigned to that name, and the silence is usually total. This is not because the record was lost. The Dawes Rolls survive today, complete and searchable, housed in federal archives exactly as they were compiled over a century ago. The names are there, the numbers are there. What has vanished, in the overwhelming majority of cases, is any family memory of what came after enrollment. Somewhere between the moment a name was written into that roll and the present day, the land attached to it slipped away from almost everyone it was assigned to. That gap is the entire subject of this video. Not whether the entitlement existed. It did, and it is documented with a precision most historical land claims never receive. The question is, what happened between the granting of that entitlement and now? Because, whatever it was, it happened to nearly everyone at once, across 5 nations, within roughly a single generation. That kind of uniform outcome is not an accident of individual bad luck repeated thousands of times over. It is the signature of a system, and the first thread of that system begins the moment enrollment stopped being just a name on a page and became something with a specific legal classification attached to it, a classification that would quietly decide who kept their land and who did not. Once a name was entered onto the rolls, it did not remain a simple entry. Commission officials attached a specific classification to each enrollee, and that classification, more than almost anything else in the process, determined what would eventually happen to the land assigned to that name. Enrollees were recorded by degree of Indian blood, ranging from full blood to varying fractions of mixed blood, and by additional categories including intermarried citizens and adopted citizens who had gained tribal citizenship through marriage or formal adoption rather than descent. A separate category existed for freedmen, formerly enslaved people and their descendants who held citizenship rights within these nations under post-Civil War treaty obligations, and whose enrollment carried its own distinct set of complications that would shape their allotments differently from those of blood citizens. This classification was not incidental bookkeeping. It was written directly into the legal status of the land itself. Once allotments were surveyed and assigned, each parcel carried a designation determining how freely it could be sold, leased, or mortgaged. Allotments belonging to full-blood citizens and to minors were generally classified as restricted, meaning the owner could not simply sell the land on the open market. Any transaction involving that parcel required approval through a formal legal process. Allotments belonging to citizens of lesser blood quantum, or to those classified as competent adults, were more often designated unrestricted, free to be sold or leased without that additional oversight. On paper, this distinction reads as protective. Restriction existed, according to the language of the era, to shield citizens presumed less familiar with commercial land transactions and legal contracts from being pressured into unfavorable deals. Full-blood citizens, who were statistically more likely to have grown up within tribal governance structures rather than the American commercial and legal systems now being imposed on them, were the group federal officials most often placed under this protective status. In principle, restriction meant a court had to review a sale before it could happen. In principle, that review existed to stop exploitation before it started. But protection built into a legal system only functions if the system enforcing it is itself trustworthy. And this is the fork the story now stands at. The same restriction that was supposed to guard a full-blood citizen's allotment against a bad sale also meant that citizens' land could not move at all without someone else's legal signature. For a competent adult, that meant petitioning a court directly. For anyone classified as a minor or as unable to manage their own affairs, it meant something more consequential. Their land, their lease income, and often their money would not be managed by them at all. It would be managed on their behalf by someone appointed to do it for them. That role had a name, and a rapidly growing population of 5 tribe citizens, simply by virtue of their age or their classification at enrollment, were about to be placed under it. Thousands of children enrolled on these rolls inherited allotments before they were old enough to legally control anything attached to their own name. The system built to hand them that land was, in the very same motion, about to hand control of it to someone else. The mechanism responsible for this transfer of control was guardianship, and the exact legal trigger has a date attached to it. On the 27th of May 1908, Congress passed an act stripping the Interior Department of its oversight authority over Indian minors and incompetents, and handing that jurisdiction to local county probate courts in Oklahoma. Overnight, decisions that had run through federal officials now ran through county judges, many of them elected locally, with no federal review standing between a guardian's petition and the land it concerned. Given how many 5 tribe citizens had been enrolled as children, and how many full-blood adults had been classified in ways that questioned their legal competence, the population eligible for guardianship was enormous. By 1923, an estimated 4,000 professional guardians were operating in Oklahoma, managing Indian estates that ranged from a few $1,000s to well into the millions. A guardian's authority was not narrow. Once appointed, a guardian could petition the court to approve the lease of a ward's land to oil companies, farmers, or other tenants, and could collect and manage the income those leases produced. A guardian could petition to sell the land outright, subject to court approval. A guardian could be paid a fee out of the very funds and property they had been appointed to manage. None of this required the ward's consent in any meaningful sense, because the entire premise of guardianship was that the ward was not considered capable of consenting in the first place. For a child who had inherited an allotment or an adult classified as incompetent, decisions about their own land were made in a courtroom they may never have entered. The sheer volume of these cases is difficult to overstate. As allotment proceeded across the Cherokee, Choctaw, Chickasaw, Creek, and Seminole Nations, local probate courts in eastern Oklahoma found themselves processing guardianship petitions by the thousands. Each petition represented a parcel of land and a stream of income. Oil royalties in particular. Once significant mineral deposits were discovered beneath allotted land that would now flow through a guardian's hands before it ever reached the person it legally belonged to. Publicly, this system was described in the language of protection, a safeguard against citizens unfamiliar with American courts and contracts being taken advantage of by outside interests. What that framing did not anticipate, or perhaps did not want to examine too closely, was what happens when the position created to prevent exploitation becomes, itself, a position worth exploiting. A guardian did not need to physically seize land to profit from it. A guardian needed only to be appointed. Once appointed, every subsequent decision about that land, whether to lease it, to whom, for how much, whether to petition for its sale, ran through a single point of legal control that the original owner had little power to challenge. By the years following the 1908 Act, this quiet infrastructure, thousands of guardianships, courts accustomed to approving land transactions with minimal scrutiny, and vast new oil wealth flowing beneath formerly unremarkable farmland, had assembled almost everything necessary for what came next. It had not yet been exploited at scale, but the structure was in place. The volume of cases was overwhelming for courts to meaningfully oversee, and word of what this land was now worth was beginning to travel well beyond the borders of the 5 tribes' own communities. That word traveled fastest among a specific group of men the historical record itself came to call grafters, a term newspapers were already using within a few years of the Dawes Commission's work. They were attorneys, land speculators, local merchants, and in some cases county officials themselves. And they understood something the guardianship system had not adequately protected against, that legal control over land was just as valuable as land itself, and far easier to acquire. The most direct route into that control was the guardianship petition. A grafter, often working through a sympathetic local attorney, could petition a county court to declare a full-blood citizen legally incompetent, or could position himself to be appointed guardian over a child who had inherited a valuable allotment. Courts, overwhelmed by sheer case volume and operating in a system where such petitions were common and rarely contested, approved a striking number of them with minimal investigation. Once appointed, a guardian's authority over that ward's land was, for practical purposes, total. Oil leases could be negotiated with terms that favored the leasing company far more than the ward. Guardian fees could be drawn from the very income the land produced, sometimes consuming a significant share of it before a dollar ever reached the person it belonged to. Restricted allotments, the parcels specifically protected from unsupervised sale because their owners were classified as full-blood or otherwise vulnerable, required an additional step before they could be sold outright: a formal petition to have the restriction removed. This step, designed as a safeguard, became instead a predictable procedure. Attorneys working for land companies grew practiced at filing removal petitions, often bundled with guardianship appointments, and courts approved them with a regularity that turned what was meant to be exceptional into routine. Once restriction was lifted, land that had been legally protected could be sold like any other parcel, frequently for a fraction of its actual value, particularly once oil had been discovered beneath it. The pattern that emerged was not random. It fell disproportionately on those the classification system had marked as most in need of protection: full-blood citizens, children who had inherited allotments before they could legally act for themselves, and freedmen enrollees, who in many cases faced additional legal obstacles and discrimination within the same courts meant to safeguard their property. The very citizens the restriction and guardianship system had been built to shield were, in practice, the ones most exposed to it being used against them. This is the mechanism the opening of this video promised to explain, and it is worth stating plainly, because it is the detail almost no descendant is ever taught. The land was not, in the majority of cases, seized outright. It was not taken through violence or open theft, though instances of outright fraud and forged signatures did occur. It was, far more often, transferred through a legal process that looked, on paper, entirely proper. A court appointed a guardian. A court approved a lease. A court lifted a restriction. A court approved a sale. Every signature was real. Every document was filed. The system built to prevent 5 tribe citizens from losing their allotments to exploitation became, through the guardianship structure itself, one of the primary instruments by which that exploitation occurred. The scale of what this produced is measurable, even if no single ledger captures it in full. Within a relatively short span, following the 1908 Act, a substantial majority of the land originally allotted under the Dawes process had passed out of the hands of the enrollees or their direct heirs, moving instead into the ownership of the individuals, companies, and banks positioned to acquire it through this legal pipeline, a pattern later documented in exhaustive detail by historian Angie Debo's research into the era. It happened parcel by parcel, guardianship by guardianship, petition by petition, across thousands of individual cases that, taken together, amount to one of the largest legally facilitated transfers of indigenous-held land in the country's history. Not hidden, not undocumented. Recorded, case by case, in the same court systems that authorized it. What remains, more than a century later, is the paper trail itself, the rolls, the guardianship filings, the court petitions, still sitting in archives, still bearing the names of the people this happened to. Within a generation of allotment, the majority of the land granted to 5 tribe citizens under the Dawes process was no longer in their families' hands, not because the entitlement had been a myth, and not because the loss was scattered or coincidental, but because a system built around classification, restriction, and guardianship had, case by case, moved that land into other hands through processes that were documented and legally sanctioned at every step. What survives today is the record of both halves of that story. The Dawes Rolls still exist, complete and accessible, holding the names, the roll numbers, and the original entitlement exactly as it was recognized when the Curtis Act forced this process into motion. Alongside them, in the same courthouses and archives across eastern Oklahoma, the guardianship files and land transaction records still exist too, naming the guardians, the attorneys, and the companies that acquired what those allotments once secured. The land moved. The paper trail describing how it moved did not disappear with it. If your surname appears on this roll, the history is not abstract, and it is not unresolved in the sense of being unknown. It is traceable, by name, by roll number, by county courthouse, to the exact sequence of decisions that determined what became of your family's allotment. Some families kept their land, most did not, and now you know precisely why. Drop your surname in the comments if you find it on this list, and tell us which of the 5 tribes your family belonged to. If you've ever heard a fragment of this story passed down, about land, about a guardian, about an allotment that didn't stay in the family, share it. Those fragments are how this history gets put back together. If this mattered to you, subscribe. Every